in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, this honorable court. Gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. Our first case of the day is Gregory versus State of Florida. You may proceed.
Thank you, Your Honor. May it please the court. My name is Richard Kurtz. I've been appointed to represent Mr. Gregory on his convictions for first-degree murder as well as his ultimate sentence of death.
So you were appointed, you're a court-appointed attorney, not
Yes.
retained, and you're not with CCRC or the public?
That's correct, Your Honor. Yes. And I often handle these just at the trial level, but this is a case that I did not handle at the trial level, and I was appointed later at the request of the Chief Judge of Daytona to take this on the appeal, and that's why I'm here today. The primary issue, or not the primary issue, but there's 6 issues that I'd like to address, and I think we'll have time to go cover each of them in order, but of course I'll follow the court's direction at whichever we go. The first issue, Your Honor, is that the appellant filed a legally sufficient motion to recuse the judge, and the judge did not indeed do that. In the briefs, I see nothing in response from the state to suggest that the technical form of the motion to recuse was insufficient. So then we must be addressing the issue of whether or not the facts inside the motion to recuse are going to rise to the level of allowing a reasonably prudent person to believe that he would not get a fair and impartial trial.
Are you allowed, or I mean, is the judge allowed, or are we allowed in reviewing it to look at when there's a statement made, what the statement was immediately after, and in another situation where a word is used one way that it actually was another? In other words, can we look at the bare transcript and review it to see if it's legally sufficient? Or do we have to, if you pick out, if a defendant picks something out
Sure.
in a colloquy, is the court and this court bound just to look at that out of context statement?
I think that's a yes and a no answer, and I'll see if I can answer it for you. This court is normally, as an appellate court, used to looking at the cold transcript and going, did he say it? Did he not say it? Is it in the transcript or is it not in the transcript? This is a unique situation. In this situation, the trial judge, actually pursuant to the rule, shall not pass on the truth of the facts. In paragraph F of the rule, it specifically says, the judge against whom the initial motion disqualify is directed shall only determine the legal sufficiency, which we talked about, that the state has not objected to any of the form, and shall not pass on the truth of the facts. And the case law, as this court has interpreted it, if I'm just one last second, the case law that this court has provided in Arbelez 898 Southern 2nd at 25, the court indicated the primary consideration is whether the facts alleged, if true, is what this court said, if true, would place a reasonably prudent person in fear of not having a fair and impartial trial. And to answer Justice Pariente's question, what you're asking me is, the words obviously were said, at least the prophetic phrase was said by the trial judge, that this statement 8 months prior, that if I catch him with somebody else, I'm going to kill her, the judge did say on the record that I find that would be prophetic. Prior to and afterwards, he did say some if this and if that, and I recognize that. And to answer the court's question, and it's unique and interesting that
Well, I feel like you haven't really answered what I asked you. I realize, well, nobody disputes that he used the word prophetic.
Sure.
But then he said if Gregory was the one who committed the murders. So are we allowed or not allowed under your version of the law to look at the context in which the statement was made?
I would say you're not.
Well, and then we would disagree about that, because it's one thing if you want to say, well, the judge, at a bar the night before, makes some outrageous statement of what that the judge said something.
Certainly.
And there's really not a way to test that. But when it's something we have always looked at, whether it's the context of a colloquy where a judge makes a statement, otherwise a defendant could take any line out of context and say that's enough to recuse him. And standing alone, the one line might sound like that the judge could have prejudged the case.
Certainly, and I understand the court's position on that, and I look at the rule and I seek the court's guidance in some of the appellate decisions, and the common theme is it doesn't matter if it's true or not, it's how the person, the appellant, the defendant was made to feel by the statements that were made. Obviously, him being said
But
that
it's got to be a reasonable defendant, right?
Absolutely.
I mean, it can't be something fanciful. And I mean, I understand the point you're making.
Yes, sir.
But it seems like to me you could, one perspective on this is that when the claim is about something that happened in open court,
Yes, sir.
to provide an affidavit and to provide a motion that does not actually give the context in which the statement occurred, it would make the affidavit and the motion itself facially insufficient. Because it just kind of stands to reason you cannot look at a word out of the context. And when it's something in open court, readily available, I would question whether it's facially sufficient just because of that, the lack of providing the context. Do you understand that?
I do.
Respond
and
to
actually, absolutely. There's no case law out there or any rule or any guidance
that. Well, we
that
make
says
case law here.
That's why that's excellent. Thank you, Your Honor. And this is where we're going with it. There's nothing.
You may not.
I understand that as well, Your Honor. What I'm trying to say is there's nothing out there that says that if in open court and it's a misinterpretation or the defendant disagrees with the court or that's not how they recall it, then there's nothing that says order the transcript.
Let me say this. You're not the lawyer who filed this.
Yes, sir. Correct.
But I find it somewhat troubling that an affidavit, a motion is filed by the attorney, which presents this in a light that I think can only be described as misleading.
And I understand the court's concern with that. And actually, obviously, as being a trial lawyer, things are happening and coming and going at us that we interpret in speed different than somebody else would consider it. And obviously, if you look at the transcript, it's not exactly what we thought. And if you look at the news report that was attached to the motion, actually the reporter who actually was there apparently came away with the same feeling. But of course, I know it's a news reporter, but in essence, what he said was exactly, Parsons said, the judge, while there is some time delay, it is quite prophetic.
How long after the statement was made by the judge in court was the motion filed?
It was timely because the trial was 15 days later, so the motion was filed and heard. I don't have the exact time. Actually, I do. The statement was made on the news report February 7th, and the motion was filed the same day. Same day. So he didn't have the benefit of a transcript, obviously, at that point. And interesting, what we talk about is if the facts were true, is what the case law in the rule says, because, as pointed out, he put in there that the judge used the word refreshing. And if you read the transcript, he didn't use the word refreshing. So I would submit to you that the attorney was not trying to be misleading, and the defendant wasn't trying to be misleading. As they were sitting there, they thought they heard him say that it would be prophetic, and then refreshing to hear a voice that has been silenced.
Well, now, that really raises something that maybe we haven't dealt with that. But if someone mishears it, or after they hear one thing, sometimes we're in the heat of the moment, and we think we hear something.
Sure.
You said that, and the person, no, I didn't say that. Now, if that's fine in normal discourse, but in court, maybe it's not as then, it's good to hear that the lawyer filed it immediately, but there's also a court reporter right there. So it would still seem to me that the lawyer should have gotten exactly what was said. But if you misstate what was said by the judge, and there is the transcript that clearly explains what it is, are you saying again that neither the judge nor this court can look at what was actually said in deciding whether the person had a reasonable fear that the judge would not be fair and impartial?
No, I mean, that would be common sense. If we have a record on appeal, we would want to do that. I'm just saying is that so far, I've not seen any guidance from the court on that issue that says they should get a transcript and compare it. What it says is they're not to pass on the truth. Therefore, we're not going to consider whether
Do you think that as a trial lawyer, and you said you're a trial lawyer, that would be practice, that if you're going to file a motion and you do it timely, that you get the actual transcript and make sure it's accurate?
That's my practice. But in essence, coming to the rule, it still says the judge is not to pass on the truth. What we're talking about now is getting a transcript to decide if it was the truth. But the rule says you don't pass on the truth, and the case law says even if it were true, which insinuates also that they could be wrong. And that's what the case law says, and that's what the rule says. That's why we had a little disagreement in the beginning where we can talk about it. The rule says you don't pass on the truth of it. So you have to assume that the affidavit, coming from how the client is made to feel.
That in fairness, that, again, because we've got defendants that make some fairly outrageous statements, and that rule maybe needs to be adjusted, but when it's statements made by a judge in open court.
Certainly.
To say that the judge can't look at the transcript and point out the correct thing, and that would be a ground to recuse the judge just by them correcting the transcript would be not in accordance with the intent of the rule.
Certainly. And I know the attorney involved in this thing, I don't think anybody was intending to defraud. It's as you're sitting there and you're listening to it, this is what I thought, and more importantly, it's not what the attorney feels. The case law also says it's not if I think that the court's going to be fair and impartial, it's what the client feels.
Sure, but the client's sitting there all the time thinking, this judge, someone's out to get them. I mean, they're sitting there, their
Certainly.
life's at stake.
Certainly.
So you can't, I mean, I think what Justice Kennedy was saying, the fear has to be reasonable. Someone's sitting there and they're not expert in court proceedings.
Certainly.
This judge, and let's just go back to what was said, he made a statement that the statements 8 months prior, which you're contesting as a separate point, was that if I ever catch her with someone, I'm going to kill her, was relevant. And what he said is that whether he should have used prophetic, it's that he was using in the context, in my view, that this was extremely relevant because, in fact, that's exactly what he did. So he ends up saying, if it ends up that he's the one that killed her, then what he said was prophetic. What's wrong with that?
I understand.
Counsel, is this your strongest issue? You use over 30 of your time.
Well, nice response. Procedurally on that, he had already gone to a trial with another judge, and so he wasn't like he was form shopping. He was only 15 days out when, at this one hearing, he hears these phrases and he immediately files the motion. So, thank you. The next issue would be Mr. Bowling's statements. Mr. Bowling, the person we're talking about, that 8 months prior made this statement. My argument to be to the court very succinctly is a threat 8 months prior without any plan of action in between is too remote in time. A threat to kill somebody, if I catch them together, I'm going to kill them, and ultimately he's on trial for murder.
I can understand if you said that somebody generally 10 years before said, if I ever catch a girlfriend with another person, I'm going to really get that other sort of a general thing.
Sure.
But this was about this victim and specifically relevant to his obsession with the fact that, and they had a child together, so that if I ever catch her with somebody else, I'm going to do that. I think that it's not remote, and I think we have ample case law to show that it is extremely relevant in this situation. What's your strongest case that it should have been kept out?
That it's too remote, that it's too prejudicial.
What's the cutoff?
I'm sorry?
What's the time cutoff? Is there a magic number?
Well, I anticipated that question as I came here, and I looked at the case law on it. In the cases that's cited by the state, the one case refers to 3 weeks, but that's a prior incident of violence. There's another case in here that talks about 5 months, and that actually is only for judgment of acquittal purposes. That evidence came in. There was no argument about the admissibility of it. I think once you start getting past 3 months or 6 months, then you're stretching it. The question is, where do we put a number? Like 16 for driving,
Is there
21?
authority for that proposition?
No, sir. Everything is basically up to the judge to determine what.
Well, it's an abuse of discretion standard, right?
Yes, sir. Yes, sir.
Well, how can we say that we'd have to say that no reasonable judge could decide that was relative and probative?
If there's nothing happening, if there's no threats or no plan of action put into place in that 8 months, 8 months ago was July of last year. People could have said many things, but it doesn't mean that they were going to do it.
Was he in jail at the time?
No, Your Honor.
He was incarcerated after that?
Correct. This was to a coworker, construction worker, he also said the same thing, said that we were joking about it. And this construction worker friend said, I'd beat her up. And he said, well, I'd kill her. And the construction worker that testified said, we blew it off. It was a joke.
Well,
That's
then
why
you
it was
have, therefore, that issue of whether it really meant that he meant to do it.
Exactly.
Where's the harm? Looking at it, You're sort of saying that they were able to cross-examine to show that it was not really a threat.
He's on trial for first-degree murder, and he made a threat 8 months ago. Obviously, the state thinks it's prejudicial, and that's why they're fought to introduce it. So I would submit to you that under those set of facts,
But that's not the test for prejudice. I mean, certainly any evidence against your client is
Absolutely.
presidential.
Absolutely.
So we're not looking for whether it's favorable or unfavorable to determine prejudice.
I understand.
It is if you have the opportunity to fully air it, and it is presented to the jury by the defendant as a joking kind of situation. Again, where is the prejudice?
I'd stand by my previous argument, Your Honor, that I don't find that it was relevant based on the time period that it was passed, that nothing happened in between.
Were there other statements made during the course of this time period to other people that he?
No, Your Honor. Actually, what the testimony was, and I was going to address it, you asked me about time period, what would be appropriate. What was not objected to, and it's not being argued here, is that statement was to a coworker 8 months prior. While in jail, 2 months.
I'm talking about closer in time.
2 months prior. 2 months prior, while in custody, he made the comment to an inmate. That was not objected to because that makes sense. That is more closer in time and would make sense. And the 8 months is what we're saying is a stretch. I'm going too far.
But the same kind of statement.
Yes, Your Honor. Exactly. And the next issue would be...
How long had she been seeing someone else?
He went into jail month, 2 months, but one thing I was going to talk about, we can't forget that he finds out that she's seeing this person on July 4th. He's out for a couple of months, and he's seeing her. He's going over for the birthday party. He's going over to the house 2 or 3 nights a week. He stays the night over there.
Isn't he trying to get back in with her?
Absolutely. Yes.
And he failed?
When he walked in the house that night and found her in bed with another man, he had conceded that he failed, and he reacted the way he did. Yes, I mean, he tried, and she wasn't rebuffing him. They were together. The family was upset.
It wasn't so cut and dried. He walked in and saw her. I mean, he actually was outside of the house and watching them, and
there was some testimony on that from a
so
jailhouse informant. I would say that the timeline the law enforcement set out does not allow that because it was at 3 or 4 in the morning, and they were sound asleep in the bed. Clearly, they must have had time to go to sleep and be sound enough asleep. It didn't seem to walk in and they were awake. So I would dispute that, and I think the trial lawyers also disputed that. It does not match with the timeline of law enforcement having walked the 5 miles and walked back and having been seen.
We don't know that he walked.
No, we don't. No, we do not know that. But the state has the burden of showing did he drive, and it does not happen. So in the light and favorable defense, he walked. And that's what pretty much was argued by everybody. The other issue we have was what I believe was hearsay. This was, I submit, it was improper. There were statements made from Aldrich and Green. And we've argued that it was hearsay and hearsay in hearsay. And what happened was, and the state's argument in response was that, this is one of their opening lines, that it goes to a declarant state of mind.
Are you talking about the statement that the victim, the male victim made?
Yes, Your Honor. But see, it's not what the male victim said, it's what Mr. Gregory said. And the state of mind of a victim is never relevant in a first-degree murder case and is not admissible. So if we're trying to say that it was the victim's state of mind, then the state fails. That's classic Earhart. So we have to be looping it. So if you're trying to get it in to show, how would these people who've never met my client or talked with him be able to testify to my client's state of mind? They can't. My client made a statement, allegedly, to the victim. The victim's deceased. He can't testify to it. But supposedly he made a statement to Aldrich and Green. And then Aldrich and Green got a chance to come into court and testify about all of that. That does not apply under the existing mental state. That is a stretch. That's hearsay inside hearsay. It was done by 2 witnesses. It was clearly prejudicial. And to
let's go to the prejudicial again. I think you're correct. It's hearsay in hearsay, and you're correct that it can't go to the defendant's state of mind. But the actual comment, coupled with everything else, which said, what was the statement?
That
you ruined. Hey, guy, you
I just
ruined
want to personally thank you for having ruined my family.
Life. Why isn't that in the context of everything? Assuming there's error, harmless beyond a reasonable doubt. It's with the other statements, with the fact that there's no dispute that he's the one that, at point-blank range, killed 2 victims, and that he had a motive and he laid in wait. How is saying you ruined my life? I mean, it really almost plays into the defense that this was a guy that was trying to get back with his girlfriend, and
Certainly.
was saying
Certainly. I
to,
reckon.
to the boyfriend, hey, thanks for ruining my life, which is in fact what he felt.
I recognize that there was definitely much more prejudicial evidence that came into
But
the course of the trial.
you know, I'm not one to usually jump on and say everything's harmless beyond a reasonable
Certainly.
doubt, but this
I-
comment struck me as being the least, sort of puts your client almost in a sympathetic
Sure.
light.
Of the comments made by and attributed to my client, I will absolutely agree with the court that these are the least egregious. However, they were obviously felt strongly by the state. There were two different witnesses. It wasn't just one witness. It was two different witnesses, and of course, it was argued in closing. So I would argue that it would not be harmless error. Yes, sir.
Dyer had actually ruined. How is that admitted to prove that he actually did ruin Gregory's life?
And that's, and I 100% agree with you, Your Honor. If that's why I believe it to be hearsay is
Well, it's
obviously
not hearsay if it's not being admitted for the truth of the matter asserted.
right.
And he was being admitted to show that Dyer knew, or the defendant knew Dyer was dating Skylar. That's the reason for it, but not for the truth of the matter asserted, which was that he ruined his life. I mean,
The state's arguing is it goes to the client's then existing state of mind. I see the court's argument. I hadn't contemplated that argument from that perspective to respond to it fully, but I would suggest, so you're saying is that it goes to his knowledge that they were having an affair and therefore would have allowed that to be admissible.
but that's not the offending statement. The offending statement was that he ruined my life.
We still have the hearsay in the hearsay would be my fallback argument. That if it was just Dyer coming in and saying it, or just then I could see how the state could prevail on that argument. But being the hearsay in the hearsay, I would stand by my position that.
But if it's not, again, these are complicated issues
Yes,
when
sir.
you get the hearsay with, supposed hearsay within hearsay. But it's not really hearsay if the statement is not admitted for the truth of the matter asserted, right?
True. But at some point, it gets too tenuous, would be our argument, that if it was in a typical situation where I said it to counsel and he said it to you, then I agree with you that it wouldn't be hearsay in that. But when you don't even have either of the two people able to testify that it even happened, we don't even know that it actually took place. These people they don't know, they weren't present for the conversations. So I'd say that the circumstances surrounding it do not allow for credibility. And the last issue I want to talk on quick, so I can leave it for the state, is the cold, calculated, and premeditated. There was a reference in the state's reply brief that it was not preserved. I've shown the state that the issue was actually preserved for appeal, and the motion was actually filed on March 8th, 2011, filed a motion in limine to preclude the cold, calculated, premeditated, and also filed his own jury instruction. I provided the transcript as well, showing the issue was indeed argued and ultimately denied by the court. What I would submit is based on the set of facts that we have, though we have an argument, comment 8 months ago, and we have comment 2 months ago, as far as cold, calculated, and premeditation, the issue that the law is that killing was the product of cool and calm reflection and not an act committed by emotional frenzy, panic, or fit of rage. Next, that murder was a product of a careful plan or prearranged design. And next, the heightened premeditation must be above the normal premeditation for murder. The last paragraph is not applicable, and so I would submit to you that there's no, under the evidence that we have, that he gets out of jail, he's out for 2 months, he does nothing, and he finds out that they're together on July 4th. She doesn't die until August 21st. He's over at the house with her. He's trying to rekindle the relationship. There's nothing in there to suggest that there was some sort of careful plan.
So if it wasn't that he wasn't sure they were actually together, and when he finally realizes that they are in fact a couple, he then, whether he lies in wait for 5 minutes, 10 minutes.
I think the testimony was that he did know.
He knows there's a gun in the house. He waits, he walks past other members of the family. He knows where the gun is, and he shoots them to defenseless victim, execution style.
Your Honor, is the
Where's the passion? Where's yesterday we had a case where he said, well, it wasn't like he came home to his darling girlfriend and he discovered her in bed with cheating on him. He knew this was happening.
My quick response is what I would suggest, there's no credible evidence to that. There's a jailhouse informant who came in to testify that. Other than that, nobody saw him come in the house. Nobody saw him go where he went to the gun first. Nobody saw any of that. There were no family members awake. Yes, sir.
In reading the trial judge's order, he left out one jailhouse niche, Goebel.
Yes, sir.
He told Goebel that he used a shotgun instead of a handgun because he thought the shotgun would leave less residue.
Yes, sir.
And he was pretty surprised when he erroneously thought that he had tested positive for gunshot residue in his hand. And that tells me that he's planning. His planning is well in advance to actually use the proper or the right type of gun so that no residue is left in his hand.
Again,
That's
we're
pretty
talking
high
about a
premeditation.
jailhouse informant. My client had a lot of statements, a lot of things were done. There's no evidence to, what I would suggest is credible evidence to support that. What I point out is they were together for those 2 or 3 months. The testimony in trial was that he was aware that they were seeing each other and talking with each other. It wasn't that he finally found them together. She's over at the house. All night long that he's out partying with friends. The judge found the 2 things. One is he found that he was under extreme emotional disturbance at the time, and he also found that he was under the influence of alcohol and drugs. That whole evening, which would require a careful plan, he's out with his friends and his brother eating, drinking, partying, doing drugs. There's no evidence, no argument that he is yelling at her or that he's threatening her. He goes home, he goes to bed, like his brothers do, and ultimately, like he's done before, he goes over to the house, and perhaps it's one of those late night hookups with an ex-girlfriend, and he goes in and finds, instead of her allowing him in the bed, which he's done in the past, unfortunately there's another man in there. Let's admit that he gets the firearm, he shoots him, he drops it right there. It's not a carefully controlled plan. He didn't have gloves on his hands. He didn't do anything to protect his fingerprints as a well thought out plan would be. He drops the gun, the DNA's there, the fingerprints are there, and ultimately,
But
yes.
his fingerprints could have been on that gun anyway.
Certainly.
His fingerprints on the gun wouldn't establish anything. So the fact that he's not wearing gloves.
Well, if he's going to think far enough ahead to think about gunshot
Well,
residue.
but I mean, if he's really thinking, he's going to understand that his fingerprints on the gun won't establish anything because he's been around that house, and I think there's been there evidence that he'd handled that gun before.
Yes. Thank you. I'll save the rest of my time.
Thank you, Mr. Chief Justice, and may it please the court. My name is Mitch Bishop on behalf of the state of Florida. If I could turn to the first issue of the legal sufficiency of Judge Parsons' ruling, Judge Parsons' ruling on the legal sufficiency of the motion to disqualify him. And meeting the formality requirements, as the appellant suggests, that would be enough somehow to cross the threshold to disqualify the judge, and that's not the case. Just because he checks all the boxes of the formality requirements doesn't mean that he has a legally sufficient motion. And with the exception of the misquoting interesting versus refreshing, the truth or falsity of what Judge Parsons said, that it was a prophetic statement from Bowling and that it was interesting that the victim's voice would be heard, that's not in dispute here. So even assuming that that's true, and those are true, those happened, those statements occurred in the transcript. But even taking that in the case, this doesn't show that he has a reasonable fear or well-grounded fear that that Gregory's not going to receive a fair trial. And in context of Judge Parsons saying that Francis Bowling's statement was prophetic, he was talking about it in the context of it being relevant. And he goes on to say that further in the colloquy, in the transcript. He says that, I find it prophetic, but whether the state can do anything with that or prove anything with that is up to them. But he's talking about it in the context of his ruling that this statement is relevant.
Well, what the judge actually said is that if he did it, that's prophetic.
That's correct.
I mean,
Justice
so it's
Kennedy.
got that conditional that's so. I mean, you look at to the extent that we look at that. I mean, that's clearly not a suggestion that he prejudged it. Now, if the judge had said that his statement about killing somebody was prophetic without a qualification, then maybe if that's the whole context, he says, well, that's a prophetic statement, then that might indicate they would have more to argue about. But it seems to me the problem here is they give this affidavit which doesn't provide context for statements in open court, and I just think that on its face is deficient.
And I would agree with that, Justice Kennedy.
I thought you would.
Yes, yes, sir. But even taking that hypothetical where if the judge had just said prophetic and then not qualified it with anything else, there's case law that we have cited that even if the judge has a fixed opinion of the defendant's guilt based on evidence, things that he's heard or had proffered him, that wouldn't disqualify the judge.
Well, we don't want to get, but we don't need to get there. And,
That's
I
correct,
think
Justice
it's
Barrington.
always I'm sure, not being a trial judge, but we have two former trial judges here, you know, sometimes you wish as a judge, you say, well, why did I say it that way? The cold transcript doesn't sometimes look as good as what's going on, but we don't have to get there as to whether he prejudged his guilt, because he didn't. So we can stay with what was actually said.
Yeah, yes, Justice Parente, and that's correct. And you know, but this is simply just using prophetic as a synonym, essentially, for relevant as he's talking. And then again, the same thing, he's talking about the fact that Skylar Meekins' voice is going to be heard on these recorded phone calls with the defendant as being interesting in the context that it's relevant. And while the defendant may not like it, it's relevant because, and that's a unique circumstance. That doesn't normally happen, and that's the only context in which he's saying that. And none of that rises to a legally sufficient basis to disqualify the judge.
Would you address the CCP?
Yes, Your Honor.
As you see the calculated plan, the evidence.
Yes, and it doesn't have to be the best plan in the world where he obviously leaves fingerprints, but it was a plan nonetheless. First of all, we can back up and look at all of his motive, the soured relationship between he and Skylar Meekins, and she has moved on to another guy, and he's tried to win her back, and that didn't work. And then we have on the day or the day before the murders, August 20th, 2007, when he's out partying with some of his friends throughout the entire day, he actually calls Daniel Dyer's phone, the male victim in this case, to try to get a hold of Skylar. And so he knows that they're together that day. And then we have the repeated phone call after phone call after phone call from the defendant's residence to the Meekins residence. And actually there was a time when there's a phone call back from the Meekins residence to the defendant's residence, and the Skylar's grandmother that she was on the phone. So he knows that she's there, he knows that they're there. And we have testimony from folks that the defendant was in jail with after that he had lied in wait and watched the house for a while. And then he surreptitiously goes into this house and sneaks down the hallway. He passes other occupants of the house. He's not just on a wild, crazy rampage. He is going for Skylar Meekins and Dan Dyer because those are his victims. He goes to where he knows that a gun is located in the house. And Justice Labarga, he actually moves one rifle in order to get to another one. As regard to your question about him choosing the shotgun because he thought it might not leave as much residue, well, he actually does choose the shotgun because his fingerprint is on one rifle, the Marlin rifle in the closet. He moves it, and then he does grab the shotgun. And then
and you're basing it on what evidence?
There's his fingerprint. One of his index fingerprints is on the Marlin rifle, the barrel of the Marlin rifle.
There was some evidence that he had access to those guns past. So I'm just wondering if we're speculating here that that's what he did, or did he ever say that? Did he ever tell someone else that?
Justice Quince, I would say that was the most reasonable inference from that circumstance, because there was no testimony that he had ever necessarily handled that particular rifle that had his fingerprints on it that wasn't used in the murder, but that was still in the closet.
He did tell the inmate.
That's correct.
That he chose the shotgun.
He did tell that to one of the inmates that he made admissions and statements to when he was in confinement prior to the murder, or prior to the trial after the murder. And then when he goes into the bedroom, this isn't a circumstance where he wakes them up and yells at them and gets in a fight and argues with Skylar over why she's not with him anymore. This is a circumstance where Skylar and Dan Dyer are lying in bed asleep, and he simply just executes them at point blank range. Actually, the muzzle of the weapon was within, the forensic medical examiner explained, within millimeters of Daniel Dyer's forehead and ever so slightly touching the outer layer of skin of Skylar Meekins' forehead. And so he puts this shotgun right in their face while they're sleeping. They're defenseless. It's not a reaction to something. And most of the case law that the appellant has cited, both in initial brief and reply, involve cases where a defendant is reacting to some type of emotional circumstance. Everybody's awake, everybody's talking, everybody's arguing, or something like that has happened.
I'm aware of no law that says that you must have that kind of confrontation before it's considered an emotional response. We've had many cases here of, and many times in the context of a jilted lover, spousal, family kind of thing, where it is an emotional response, but not necessarily the argument and all that going on, but it is an emotional response nonetheless.
And that's correct, Justice Lewis. The domestic dispute, there is no such exception to CCP, and even finding the statutory aggravator of extreme emotional distress does not negate CCP, and this court has ruled that before.
So really you have is the lying in wait. What's the evidence that you think that is demonstrating this record on that, the competence of that aspect?
Yeah, one of the jailhouse inmates that he had made admissions to that he had waited outside the home and watched them go in, but we also have more.
Is that the extent? I mean, he just happened to be outside and watch them go in. I mean, is that the extent of the evidence?
Well, but that's connected to those phone calls and the fact that he knew that they were together that day and that Skylar was at the house that night.
Do we know how long he was there and waiting?
We don't. We don't have a particular time frame of that. But after the murders, there's more evidence to indicate the plot, and the plan after the murders. When he, at 4:17 in the morning, tries to call 911 and turn himself in for violating his probation. He's trying to create an alibi. He wants to be in jail at the time that the bodies are found, and that was the state's theory, and that's what he's doing in the circumstance where. He calls 911, they send out a deputy. They don't have a warrant for his arrest. He believes at this point in time that he's going to have a dirty urine sample and be in violation of his probation for using drugs, because he had been using drugs all that day before.
When was this call about violation of probation in relationship to, went to a pool or something to get the gunshot residue off of him? Where was that time frame?
Well, yeah, Justice Quince, and the inference would be that he made this call after he had already swam in the pool or the ocean.
Where was this pool?
There was a pool. There was an admission by him to another cellmate that it was at a condominium that was located right near his residence, and there are facts that there was a condominium. There are a couple of different condominium complexes.
Was he in wet clothing? He was next seen?
His clothing, when he was next seen, no, but his clothing that he had been wearing the night before was soaking wet, to include his wallet and his shoes. So he had swum fully clothed in order to try to purge himself of any type of residue or DNA.
Well, I'm not sure, though, of all this, that what he does afterwards it's not exactly a calculated, I'm going to jump in a pool. So, I mean, it doesn't exactly show a rationality. Let's stick to the before. One of the arguments on CCP, one of the arguments that has been made is that he knew for some time that she was not back with him, and he knew for some time that she was with this other person. So how does that either support or negate CCP? I mean, from my point of view, I was thinking it supports CCP because it shows that, to me, it wasn't an emotional reaction of something that just happened. But what's the evidence of what in the days before, what was going on in his life?
We can go more than days, Your Honor. We can go weeks. He's in jail from June 6th, 2007 until July 2nd, 2007 on his violation of probation. And then when he gets out on July 2nd, she's starting to move on to someone else, but on July 4th is officially when she is now with this new guy, Daniel Dyer. And the defendant he shares a child with this young lady, and so they're still in contact with one another. And there's indications that he's called her several times, called even Daniel Dyer's phone, not just the day prior to the murders, but several times in those few weeks between getting out of jail and the murders happening, to try to talk to Skylar. And so
that
he's
doesn't,
living
I guess,
with this.
what does that support? Because one argument is, well, it supports that he was perfectly okay with what, or not perfectly okay, but he was adjusting to the fact that she was with somebody else.
He's still trying to get her back. He's still trying to get her back, and he's failing at that as time goes on. And so he's forming this plan as time goes on.
What's the evidence that he's forming this plan? I mean, that's just hypothesizing that this is what is going on. I mean, as a child with this person, and is there evidence that he's trying to have contact with the child?
There's no evidence that he's not able to have contact with the child.
No, that he is having contact. I mean, that's how he's going to he'll have to make contact with the person, one of the victim, but at least one of them, the lady, to be able to have contact with the child.
Well, and again, this would...
Would someone say, is there evidence in there of a plan, or are we just saying, well, he had to have been having a plan because he knows they're together?
Well, and that it all ties in as well to the statement to Tyrone Graves in June while he's in jail, that if I ever catch her cheating, I'll blow her head off. And then the statements that... Actually, there's a statement from his brother that,
So the state's theory is that this has been for 8 months, planning this murder?
Not for 8 months, but from the time that the relationship starts to turn south and go sour while he's in jail.
Right.
And there's evidence of that from actually in a conversation between the two of them, between Skylar Meekins and the defendant. And so he starts to, this plan, the genesis of it starts there and then materializes as time goes on, as he continues to see that he's not going to get her back and that she's going to go off with this and stay with this other guy. As that continues, and he's continued to be confronted with that, that's what as this plan unfolds.
There's a statement in the judge's sentencing order that says he learned they would be together at the house of Skylar Dawn Meekins. Watched the house to confirm they were both present. Now, was that thing of learning they would be together? What was it? What testimony is it that supports that statement, that he knew, that they were going to be together that night?
On August 20th, at trial, Michael Green testified that on August 20th, the defendant called Daniel Dyer's cell phone. And Green was standing there as that. He didn't hear the conversation, but he knew it was the defendant who called and that Daniel Dyer answered the phone. And actually, the defendant wanted to talk to Skylar, and Dyer passed the phone to her. So he knew that they were together within hours before the murders.
This is one of the weakest ones I think I've seen for a while, because we're all trying to patch together things. Is there some evidence from witnesses, from something that establishes that this defendant had knowledge that they were sleeping together and that relationship had gone to that point? And what's the status on that?
Well, and
from what you're saying, it could be this was the first night that they had slept together. I don't know. From the record
that Daniel Dyer and Skylar had, and
right.
It was that there's actually evidence that it was the first night that they had spent the night together.
So doesn't that support? The don't have to necessarily scream and shout to have an emotional or have a rage reaction. You can quietly be upset and things. That's. We're talking about trying to really understand the calculated plan, other than they're together tonight and I go over there and see it. And
well, again, the fact that he knows that they're together that day, the day prior, when he calls Daniel Dyer's phone, he's calling the Meekins residence. He actually gets on the phone at some point in time, but
that's no different than this whole 2-month period that you're talking about, since he's been out of jail.
Except that this is happening, Justice Lewis, that night. This is happening.
I know, but they've been together. He knows they're dating or whatever word you want to use. Hanging out, I guess, is the phrase that you these days.
I would say that they were dating,
okay.
Your Honor. But no, this is all happening that night. So he knows they're together that day. He knows they're together that night. And we have phone call after phone call after phone call where he's trying to get a hold of them. We have several of those phone calls.
Why doesn't that demonstrate a building emotional rage kind of reaction to what's going on?
If it were, again, if it were an emotional reaction, and I'm not saying that this was completely detached from emotion.
Right.
There's emotion here. I would agree with you there, Justice Lewis, that he's upset about the fact that she's moved on. But that in and of itself, the fact that he's upset about that doesn't negate that he had a cold, calculated, and premeditated plan. And he's trying to get himself over there. He's calling Lantrip, Wayne Lantrip, his friend, calling him back, trying to get Lantrip to come back and pick him up. He calls the cab company. He doesn't get through to the cab company. He calls the cab company 2 times, and those were actually the last 2 phone calls before the phone calls ceased until 4:17 the next morning, when he calls to try to turn himself in on the probation violation.
We have cases, for example, that say that there's evidence of CCP. If one goes to some third location, obtains a weapon and brings it to the scene, that's part of the plan. They're going to use that weapon. We know he had been in the house, and that the gun, I guess, was in a closet. What's the extent of the evidence there? I mean, is clear? Is the evidence clear and competent, substantial, that he knows that there's a shotgun, and that the type of shotgun, and shells in a particular location, that it's unlocked, and all that?
And there is, Your Honor, he lived in this house for a year
I was
prior
aware
to.
of that.
And the closet that this is located in is not a locked closet. It's not a gun safe or vault or anything like that. And when you look at the photographs that are in evidence, and you open that closet, it's a relatively open space. There's a vacuum cleaner sitting there, and then there's the rifles and shotguns stacked along the back of the wall, where this shotgun was located. And then the shotgun shells that he loaded, again, and he loaded just 2 shells, by the way, when it could have taken more, but he loaded just 2 for the 2 victims that he had. And they're sitting on the shelf right there about eye level when you open the closet door, and there's the shotgun shells, a couple of loose ones, and then a box of shells, actually. And then...
And do we take from that, I mean, that he knew... When's the last time he was in that closet?
The last time he was in that particular closet, we don't necessarily know. But the last time he had been in the house, he stopped living there when he actually went to jail.
Right. I mean, it'd been over a year, right?
Not over a year. No,
about
sir.
a year.
It had been, well, no. He went into jail on June 6, 2007. The murders happened on August 21st, 2007.
It was only a couple of months.
Correct. So it had only been a couple of months.
I guess, in helping you on this, because I think this is actually a strong case of CCP, so we're maybe going to disagree about that. But to me, it's in the what time of day is it? It's at in the middle of the night?
The medical examiner testified that these murders happened at approximately 1:30 a.m.
So he sneaks in the house. He knows he's not going in there to try to talk something out in the middle of the night. I guess the question in terms of the evidence, or the lack there is what is the other motive? What is the reason he is coming into this house, sneaking in the middle of the night, and he knows the 2 of them are there, other than to kill them? I can't. So if there is, can you tell me what evidence there would be, that shows that his intent in entering there was to, sort of talk it out with them, or ask her to come back?
There's absolutely no evidence to suggest that he had any
counsel has
other.
argued this morning that he had gone to the house and had climbed into bed with this young lady, and this time he happened to encounter already an occupant. I mean, it was like, that's what the argument's been.
It had, and there are.
But what are the facts? I mean, which facts? Did he just go there and to kill, or was he going there for pleasure?
There are no facts, Justice Lewis, that he had done that, where he had gone over to her house recently to the murders. Right when he got out of jail, he actually did spend the night with her. But after that,
did he take the shotgun with him to bed that night?
He did not. Oh. he did not, Justice Perry. He didn't. But there's no evidence that he actually had been over there and spent the night with her.
Because you would agree. That would be a different. In other words, if he really was coming in there, sneaking in past the grandparent, whatever, to get in bed with her, but I would, and maybe that's why we're seeing this a little differently. I would see that as being much more, I would think that CCP then is much weaker. But I didn't think there was any evidence that his motive in coming over there was to spend the night with her.
Well, yes, Your Honor, and if he was going over there to spend the night with her and Daniel Dyer wasn't going to be there, then he wouldn't need to sneak in the house.
I thought he even saw them going into the house. Is that not part of the record, that he was outside and saw them come into the house together, or not? I mean, let's clarify that.
According to, I believe, to the best of my recollection, Your Honor, according to one of the post-arrest jailhouse cellmates, that he had made some type of a admission to that he had, this was the lying in wait evidence that he had seen them go in the house. But again, there's very clear evidence that he knew they were together that day and that he had been calling the Meekins residence that day.
You said there was the call where he calls the one victim,
Correct.
cell phone, and
Correct.
to speak to the...
To speak to Skylar Meekins, the
and
other
then
victim.
there's the other part that Justice Barga was mentioning, which was that, you know, he told another person why he picked the gun he picked.
That's correct, and he's also trying to create, make an excuse on some of the recorded phone calls after the murders when he's in jail and he's talking to some of his family members who are on the phone with him. He's trying to make an excuse for why he would have gunshot residue because he's under the false impression.
But that part, again, the part that after you do something, whether it's calculated or it's spur of the moment, the fact that you are afterwards going to try to prevent detection doesn't, to me, support a cold, calculated, premeditated plan. So I'm a little bit, we may have some cases, I don't happen to agree with that, because anybody, after they've killed the person, may try to cover up their tracks, and that's not necessarily part of their original plan.
And I would argue, Justice Parenti, that it can be a part of the plan. It doesn't necessarily have to be, and it doesn't have to be the linchpin of the entire plan, but it's just one other factor to consider in that plan, that he was trying to cover his tracks. He was trying to create an alibi. He wanted to be in jail when they found the bodies so that he had some type of an alibi. He wanted some type of an excuse for why he had gunshot residue, where he believed he would have gunshot residue on his hands, even though he didn't, because he had swam fully clothed after the murders. And if there are no further questions.
Well, actually, the hearsay in the hearsay, I think that it may not be that the statement that came in is, but it can't come in for the state of mind of the defendant. I mean, we have where it's being uttered by a deceased victim to another person. So on the alternative, your alternative argument, that it shows that he knew of the relationship. Isn't that still, for the truth of that the statement was made, isn't that still that he even made the statement? Isn't that the concern of the hearsay rule, is that the truth is, how do you know it is? Because the person who's made it is dead, and it's relating a conversation that dead person had with the defendant.
There is the hearsay within hearsay analysis here, but both levels aren't hearsay. It's not. I don't know that it's being offered to prove that he had knowledge. It can be used to prove that he had knowledge.
State of mind is an exception, and state of mind is it's not, we say, well, it's not really the truth. It's what he thought. So if it is a statement made by somebody, it doesn't have to. If it fits into that, but when it's hearsay within hearsay, that's really the problem. So it's not whether the defendant, how do we know the defendant made that statement to begin with?
Well, and other than the fact that of the testimony we have, that's what we have for it. But again, his statement to Daniel Dyer, "I want to thank you for ruining my life," is not being offered, as Justice Labarga suggested in a question previously. It's not being offered to prove the truth of the matter asserted. It's being offered just to prove that this is what Gregory believes.
Well, if it went to 10 people and it was at some point the ability to cross-examine for anything about it is lost. I mean, that's my concern with it. I mean, I happen not to think I think it could be used in. I'm not sure how harmful it is. So it's more of that, but I was just, and I first bought the idea that it's, as long as it's offered to prove that he knew of the relationship, it's not being offered for the truth of the matter, but I'm just not convinced that isn't still the truth of the matter.
It's certainly not offered being offered to prove the truth of the matter that Dyer actually ruined Gregory's life, the actual content of the statement. If it's being offered to prove that he knew of their relationship, the existence of the relationship, there's ample other evidence that he knew of the existence of this relationship, and so it would be harmless and beyond a reasonable doubt under those circumstances, cumulative to that other evidence. And if it's being proved to show his identity, because that was actually the defense at trial, that someone else had done this, then there's plenty of other evidence to prove his identity. The most pertinent of which.
Was there any credible other suspect?
No, Your Honor. There was no other person or person of interest in this. So, if the court has nothing further, we would ask that you affirm the trial court's rulings below. Thank you.
Thank you for your arguments. Rebuttal.
I'd like to do what I believe is correct, a couple of things. One of the questions asked was, had he been in a relationship with her during the time out? And if you look at the state's initial brief where they put the statement of the case at page 43, it lays out, once he got out of jail, he was taken to her house, and he stayed the night at her house. And if you read through this, they were every time through July and August, this is their recitation, they were together and they were lovey-dovey, and they said that he spent the night at her house, and they have a child together, and they seemed happy together. They had an ongoing relationship for those 2 months. There was not a careful plan going on, which is required under...
Well, when was the last time he spent the night at her, wherever this was that...
I don't recall the exact date, but the trial testimony will be obviously what the transcript is, but my recollection is a week to 2 weeks prior.
I mean, the problem is the defense wasn't that I did this in the heat of passion. The defense was I didn't do it. So
We always control our defendants, but definitely if you look at the cold calculated premeditated jury instructions, there's 4 prongs that have to be met.
But how do you give the opposite thing, that what happened was let's assume he did it.
Okay.
Is there evidence to show that he didn't know that Dyer was in the house that night?
In the light most favorable to the state, again, it's a jailhouse informant, but you asked the question about what was he doing outside the house, how long was he outside the house. If you look at their recitation of the facts at page 31, what it says is that Goebel said Gregory told him he had been watching the Meekins' house and saw Dyer go inside. That's all there was. There was not. So if he saw that, Your Honor.
Well, but the judge accepted that. You're
Yes.
not asking us to
And
reweigh
that's
that.
exactly. So if we assume that to be true, and following your line of thinking on it, that he sees that, one of two things. He's getting upset, angry, because it's the first time he's going in there, and it's that anger and passion that goes with domestic relationships. Even if it were he went in there to get the gun and kill her, that's premeditated murder. I will absolutely concede. But it's not heightened premeditated murder, which is required under CCP. And there was no evidence of a careful plan. Again, the killing, prong one, the killing was the product of cool and calm and not prompted by emotional frenzy.
Is there enough evidence that he knew, because again, would it be different if he brought the gun with him?
Absolutely.
Okay. Is there enough evidence, competent substantial evidence, that although he didn't bring the gun with him, he knew exactly where the shotguns were, and that was part of his plan? Is that a speculation, or is there competent substantial evidence?
There's substantial evidence that he had lived in the house before, had been in the house, and knew that the weapons were there. He obviously didn't bring the firearm in.
And he told somebody, again, I never loved this jailhouse snitch thing.
Certainly. He never told anybody else other than a jailhouse snitch that information.
Well, this whole case is built on jailhouse.
Absolutely.
That's all it does.
I've got clients who
but
testify.
Go back and,
I understand.
Go back and address, because the bench has pointed out to you
Certainly.
that this scenario, that we have an individual calls and calls and calls and knows that the person he loves most now with some other guy, he knows where they are together, then goes to the house and he lays in wait, watches him go in, and he waits until everybody's asleep, and then he surreptitiously enters this house and goes immediately to the closet, grabs the gun, and goes and executes his cold and calculated, premeditated plan.
You added that in at the end there.
Well,
I agree that if you agree with the beginning that he's calling that day and becoming upset about it, and during that day he's becoming into an emotional frenzy to the point where he goes over there and does that, I think that that's first-degree murder, premeditated murder. It is not heightened premeditation. There was not some long plan. And the law says not by emotional frenzy, panic, or fit. And what we've described is going into that.
Hasn't he known for 2 months?
Absolutely. That's why. And he's getting along wonderfully with her. And he's sleeping over the house. They're having a child together, a birthday party. There's not this emotional frenzy building up. It's only on the last night when the state concedes it was the one time that they were ever together. The only time that they were ever together was the night that he went in there. And I would submit to the court that there's no other evidence to suggest, other than to suggest that he walked in there.
And what he said 8 months before becomes prophetic, which is, if I ever find her cheating, I will kill.
It may be prophetic, but it is not cold calculated and premeditated, because there was no calm plan implemented, and there was no heightened premeditation. He may have said it 8 months ago, but he was with her wonderfully, spent time with the child's birthday party, they maintained a relationship.
I thought you just answered Justice Poster's question that he had known for a couple of months that she was, in fact, seeing the other victim.
They were dating or hanging out. They knew, because if you remember the conversation, my client had actually called the victim's phone to talk to her. He knew about it, and he was not putting forward some plan. There was no violence. There was never a threat to Dyer. She was never a threat to her. Out of all of the testimony he was in, he never said, argued to her, or any of the jail calls, actually physically threatened her or him.
To me, that makes it worse. That's maybe how we look at the evidence.
Yeah.
If he killed the boyfriend in some fit of passion, but he executed both of them while they were sleeping.
What I was trying to argue is that he's doing fine, he's calm, everything's fine. When he walks in there and finds them in bed together, it's when we have an emotional frenzy, the jealous lover, and that's when the firearm's brought out. Other than that, in the first 2 months, there was no jealous frenzy, there was no anger.
Well, if he had gone in if he went in right after he saw them go in, but he waited long enough for them to be asleep, if he wanted to confront them, he would have gone in right away.
I don't find that testimony credible for this reason. Why would he be standing outside the house? It didn't say she went in. If she's already in there, why is he outside the house and not inside with her? I find the testimony to be incredible, because if he's a girlfriend there and he's been staying over 2 or 3 nights a week, why doesn't he just go in the house?
But we know there wasn't, can't we infer from the fact that other people present in the house, there wasn't some argument that went on in the house. We know that, don't we?
Correct.
We know that.
Well, nobody woke up.
Well, we know, and the circumstances of the bodies being in bed like they were when they were murdered. So it seems to me there's an overwhelming inference that he stealthily went into that house. Now, that is with a purpose. You don't go into a house at that time of the morning stealthily when you've got good reason to know that the man who's taking the woman away from you is there. You don't go in there without a purpose. And if the purpose may be to confront somebody, that's not what happened.
Assuming we took the snitch's testimony as the gospel, then yes. But don't forget, during that 2 months, he was going over there at night.
We have not said that a snitch's testimony is to be dismissed as irrelevant or incredible.
I agree. No, Your Honor, I agree. And I think we have to look at the rest of the surrounding circumstances. And the rest of the surrounding circumstances does not support that he laid out there and only watched him go in and then went and grabbed the gun. He had been going over don't forget that the testimony undisputed during the course of the trial was that the family would all go to bed and he wouldn't be there. They would all wake up and he'd be there. So surreptitiously, he was going in and out of the house for a couple of months, except that he was going for a hookup versus what he found.
Again, when's the last time that he was in there to sleep with the mother of his child?
I don't know the exact date, but remember, he was out of jail for 2 months, and it was going on during that 2-month period. It wasn't that it was like, nobody said it was just the first week when they got out. It was going on for the course of the 2 months.
There's testimony
Yes, Your Honor.
that from who testified that he went regularly over there to sleep there from the time he got out of jail to close in time to the murder?
Well, I'm not going to use the word regularly, but what he said was, the testimony at page 43 of the state's analysis of the facts, Schuyler would call Gregory and he would spend the night at her house. They would be together, continue to talk to each other through July and August. They were together for the child's first birthday party. They seemed happy. The witness was Leah Romanek.
But hadn't something happened where they've had a conversation where she's saying, look, I'm moving on. I'm moving on.
That was while he was in jail. That was before he got out. That was when he was in jail. That's on the jail calls that came in. When he get out, where does he go? He's taking the first night to her house. They sleep together on the first night out of jail, and they continue for the next couple of months. Yes, he was seeing somebody else. Yes, she was seeing him. Yes, he knew about it because my client was well aware of it. And the hearsay would never have been introduced for that topic because he was well aware of it. He even called him on his cell phone. Everybody was aware of it. So he stayed there off and on for that 2 months. And I believe it was, and I'm not positive of the site, but it was like within a week to 2 weeks is when the last time he had been over there. He'd been going over there surreptitiously before. Everybody was asleep. Nobody woke up. And he would be there in the morning. Matter of fact, so the family was upset about it, was the testimony, is that she was playing the two guys situation.
You have well exceeded.
Yes, thank you, Your Honor. Obviously, there's a couple of issues. One is the hearsay, and hearsay I would submit would not have been for the fact that he had knowledge of this relationship because it was clear there was other testimony. It was clearly for the truth of the matter asserted, and I would argue there's not harmless error because there were two witnesses and it was obviously argued in closing. And as far as the cold, calculated, and premeditated, if we look at this court's guidance on the 4 prongs, it absolutely fails. There was no evidence. Matter of fact, they said that there was evidence that he was failing relationship and that it was planning. There's zero evidence whatsoever that any plan was ever put into play. He was out that night doing drugs with his brothers. He went over there. If you assume what he saw and said, he watched him go in, that's premeditated murder. It's not a careful plan or prearranged design, and it's not heightened premeditation. It's first-degree premeditated murder, and I ask the court to either convert this to a life sentence or send it back for a new sentencing hearing. Thank you for your patience.
Thank you for your arguments. The court will be in recess for 10 minutes.
All rise. Supreme Court of Florida is now in session. Please be seated.
The last case on our docket for the day is Yacob versus State of Florida. You may proceed.
Thank you, Your Honor. I'm Nada Carey, representing Michael Yacob. This is a direct appeal from his conviction for first-degree murder and sentence of death out of Duval County. There are two issues, two main issues we raised in the brief I'd like to address today, and I'd like to begin with the proportionality argument. Before I do, I'd like to just give a brief recap of the facts, make sure we're all on the same page.
Well, the video is a pretty good recitation of the facts. It's hard to argue on both sides with the video.
That's correct, Your Honor, and I assume the court has seen the video. But just briefly, Mr. Yacob went into the Snappy Food store early in the morning. He confronted the clerk outside the cashier's area. It's a typical cashier's area enclosed from floor to ceiling and what's called bulletproof glass, including the door. He directed him into the area, demanded money. Mr. Maida complied, gave him money from the register and underneath the counter. Mr. Yacob then exited the cashier's area, walked around, was on his way towards the front door when he observed Maida. Maida had stood up, moved.
He didn't get very far when he exited the door to leave. It looks, I mean, he was not even right around the corner when he sees the movement.
He was directly in front of Mr. Maida when he he was probably about halfway between the cashier's door and the front door. He saw him hit the switch that locked the front doors.
Is there any evidence that he saw him hit a switch? Is there any evidence that he, the defendant, knew? It could have been that he was an alarm. It could have been this, that he knew what the pushing of the button meant.
Well, the state argued that from the video it appears he sees what he's doing, and why else would he run back to the door? He's committed the robbery, has the money.
Well,
he clearly didn't.
It just seems to me to be strange to infer that the defendant here thought the door was locked, because when he sees this action, I think it's clear that he shot the victim in response to his viewing something going on, the victim doing something in the cage.
Yes, sir.
But then he immediately goes back around to the door to the cage and shoots the victim, right?
Your Honor, the jury didn't know this, but Mr. Yacob had worked in several convenience stores, including a Snappy store.
That's not responsive to my question.
Well, I don't understand your question. Try me again.
I'm asking about the sequence of the facts here.
Yeah.
He saw something happen inside the cage, and basically you've related it correctly.
Yes.
He was basically even with the victim.
Yes.
That he saw that. He obviously did not like what he saw. He went around to the door he had just come out.
Yes.
And that door was closed. He shot the victim through the door right then.
Your Honor, he runs to the store. runs to that door as Mr. Maida goes to the door to close and lock it.
To lock it, right.
Mr.
The
Maida.
door to the cashier's area,
Can
not the front door.
I finish asking these
Yes.
questions here? I would like to proceed.
Yes, and
If you don't mind?
I would like to respond to your question.
Right.
Mr. Maida is fiddling with the lock, okay? When Mr. Yacob shoots at the door twice, the two bullets are 3 seconds apart. The first bullet hits the door frame of the lock where he's trying to lock the door. He drops his money at that point. It's very difficult to see, as you folks know, because you've seen the video. But the money gets dropped on the floor, and then he fires a second shot. It penetrates the glass.
And that's the shot that kills the victim.
Yes,
Okay.
it goes through the
now,
glass.
all
Yes.
of that happens before the defendant has gone to the outside door of the store.
That's correct.
When he goes to the outside door of the store, he seems to be surprised by the fact that the door is locked, because he struggles with it and he says, "Open the blank door." Now he shot. If he had known that the door was locked, he shot the only person who's in a position to unlock it. So I don't understand exactly what he was thinking, other than that he was reacting to something going on in there. I have another question for you. I mean, is what I'm saying, is there anything I've said that's factually inaccurate?
No,
Okay.
it's the inferences that
I understand.
think we're
You may have
talking about.
a different inference.
Well,
Okay, and I'm not sure it really makes a lot of difference
Right.
to the bottom line here, but tell me if there's anything in the record that shows that there's more than one button in there, because it looked like to me that the victim, when he first got up, he's hitting some button, but also after he's shot and is going down, he's reaching up there. It looked like to me to hit a button again. Actually, he's going down. Do you know, are there two different buttons, or?
there's one lock switch, according to.
Is there an alarm switch? Does the record reflect that?
It does not reflect that there was an alarm at all. Now, when the victim reaches up, my inference from that was that he was trying to get to a phone. I mean, I don't know why the victim, after he was on the floor, is reaching up again.
But the one area that I'm looking at,
Yes.
first shot, kind of an accidental shot, it just went off.
It's not clear because you can't see him at that point. All we know is that the bullet hits the door frame where the lock is. And then the money gets dropped to the floor. He fires the second bullet and it goes through the window. The shots are maybe about 7 inches apart. One's lower than the other one. Now, as far as the inferences, the state argued that he saw him hit the lock switch and probably knew what he was doing. Now, we can't assume that, but why else would he go back to the door unless he felt like he couldn't get out? There's no other logical reason for him to run back there.
But why does he then shoot the guy who can open the door? I mean, I don't.
That's exactly my question, and the judge says it's clear. It doesn't make sense for him to kill the one person who could then get him out. So the inference from that is he's not trying to kill him. He's trying to get in the door. He's in a panic. He runs back. He fires the gun a couple of times. I think it's likely that everybody, he and Mr. Maida, believed that that glass was bulletproof. I think it's likely that he never anticipated the bullet would actually penetrate the glass and, you know, follow a trajectory that would injure and kill Mr. Maida.
So why the second shot? I mean, I can understand the panic or whatever it was when he did the first shot. But then, as I understand it, he drops the bag of money and he sort of takes one of those stances. And so why that shot? He never thought the bullet would penetrate.
He could be threatening. He could be trying to threaten Maida. He could be trying to shatter the glass. He could be trying to get the door to unlock. I don't know. But I don't think you can infer from that he expected or intended to kill this young man.
But isn't that, but the jury found premeditated and felony murder.
Yes.
Okay. So I didn't think when we're dealing with with proportionality, I think we got to accept that whatever he was doing, the jury found, and there is evidence to support, that in his plan, whatever happened, that the killing was not accidental, because you're not contesting the finding of premeditation. But we're here on proportionality.
Well,
so am I correct that you haven't challenged?
No, I didn't challenge.
Let's try to do this, and question, answer. You did not challenge the finding of premeditation.
Well, I didn't challenge the first-degree murder conviction. I didn't challenge premeditation because it's still felony murder, so it's not relevant.
But well, it is relevant because a lot of times when they don't do special verdicts, we don't know if the jury found felony murder or premeditation. Let's assume that whether it was a moment before, because you don't need much for premeditation, whether the first shot was accidental, the second shot was intending to harm or kill the victim.
Yes. Well,
now let's go and assume that, and there is premeditated finding. How is it still not proportionate based on all of our cases that have a single aggravator of robbery? He didn't intend to kill anybody initially. We all think we have to agree with that. He didn't come in the store to kill the cashier. He came in to rob the store, and something happened. So is this closer to the ones where we say this is really not a heightened kind of situation? There's no CCP, there's no avoid arrest. Best case that this is analogous to.
Okay, Your Honor, I have to respond to the assumption that you're making. I do not agree with that. I think the court has to look at whether this was premeditated, regardless of what the jury found. I think that's a relevant factor to consider in the proportionality argument.
Well, if we find there is evidence to support premeditation,
And I can answer your second
then
question.
is it still not proportionate? I think
It is still disproportionate penalty.
So that's what I'd rather
Yes.
you argue it that way.
Yes, but I just wanted to make that clear. It's still a disproportionate penalty. There's 8 or 10 cases here that we cited. 2 of them, juries found premeditated murder. That's Scott and Johnson. In the other cases, Sinclair, Thompson, and Terry, there wasn't a jury finding. We don't even know if there was a special verdict in those cases. I doubt there was, because that was before they were giving special verdicts or required to give special verdicts. But in all of those cases, the evidence of premeditation was as much as it was here. In Sinclair, for example, he shot a cab driver twice in the head. Now, he claimed it was an accident, but of course that was belied by the medical evidence. So he shot someone point blank in the head twice. So the evidence there of premeditation, or the way the crime was committed, the aggravating part of it, was certainly greater than here, equal, and I would say greater.
The problem that you have is that your client did not allow his, I know you have a point on that, his counsel to present what seems to be some very compelling mitigation about the history. This is an immigrant, he struggled when he got here. Defendant, and we got 2 immigrants. Right. It's a tragedy case, and yet this idea that he graduated high school, that he struggled through, and all that is not presented. So if we look at a single aggravator case, but then we say, okay, but there's not much in the way of mitigation, how do we deal with that?
Your Honor, there is significant mitigation. It's in the record. The trial judge admitted it. It was all admitted in the Spencer hearing. The judge just didn't consider it. It's in the record. It's there for this court to consider. And it's believable, it's uncontroverted, and the state didn't object to it. So
but the state did object in the sense that the state, as I recall, said, we have not had an opportunity to confront these witnesses, to cross-examine them. We don't know how long their relationship was with this defendant, all these things. And so it seems to me that the state was trying to tell the judge that, look, you're going to be considering something that's totally one-sided because we haven't had an opportunity.
Your Honor, that's incorrect. Prior to the penalty phase, when the defense sought to introduce the videotape and the deposition before the jury, the state objected. At that time, the state had not even viewed the videotape. They had not even seen it. What I'm referring to is at the penalty phase. The videotape was introduced without objection from the state, as well as the deposition.
Was it the penalty phase or the Spencer hearing?
The Spencer hearing. It was all admitted. The state did not object. The state recognized that it's admissible as long as they have a fair opportunity to rebut. They did have an opportunity to rebut. They were allowed. There was one thing they wanted to admit.
Well, let me just, because I've obviously read this a little differently.
Yes.
They didn't make any argument about not having an opportunity to talk to the witnesses and confront the witnesses that were on this DVD, I guess it was.
What the state said is, I want to make an argument to support why it shouldn't have gone before the jury. That's almost a direct quote, because they knew they hadn't seen the video, and they're making an argument for their previous objection to presenting it to the jury. As far as its admission to the penalty phase before the judge, they said, We do not object. We understand that almost anything comes in here. And they later said, we want to introduce, there was the schoolyard fight, which I'm sure the court's aware of. When he was 16, he pled to, I think, third degree assault, got probation. That was the only evidence the state offered at the penalty phase. And at the Spencer hearing, they offered that to rebut the teacher's testimony that he was a diligent student. Of course, that doesn't rebut that testimony, but that was the basis for it.
But what would you say is the most compelling mitigation, whether it came in, the judge didn't find, that sort of changes the calculus, or do we need to worry about how compelling the mitigation is if this is really more in these cases where someone comes in to rob a store, does not intend to kill, something happens, a reaction, and then the murder occurred?
Well, what the court has said repeatedly is if there's a single aggravator, aggravator cases are not subject to the death penalty unless the aggravator's extremely weighty, especially weighty, and there's little or no mitigation. In this case, you've got a not so weighty aggravator, and you have a fair amount of mitigation. I understand it's not overwhelming. It's not mental illness, schizophrenia, those types of things. But it's comparable to the mitigation in Sinclair, Thomas, Terry, Scott, Johnson, Williams, Carruthers, Lloyd, and Rembert. And to answer your question, he had significant life challenges. I think that's mitigation that far surpasses little or no. He was born in a war-torn third world country. His mother was 13 when he was born. Arranged marriage. His father left. He immigrated here when he was about 12 years old. New culture, new language, obviously very different from Eritrea and Ethiopia, Africa. His father had, by that point, had a new wife and new children. There was strife in the family. The mother moved to Seattle. He stayed for a while with his father. At some point, he was removed from his father's home, social services, due to abuse by the father. And he lived in foster care shelters, a number of them apparently for a year.
Well, it's unfortunate he didn't allow the mitigation to be developed, because it's pretty clear to me there's some getting in trouble, that there is some compelling mitigation. But let me go back to
But it's in the record. It's all
except
in the record.
That I'm not sure that Mr. White's going to agree with you that it's in the record and uncontroverted and admissible the way it is.
The state didn't even object to it.
Well,
they didn't say it was not believable. It's a mother and a grandmother talking about her child. This is what we see all the time.
A deposition is usually the way we get that evidence in. Even
well, Mr. Douglas's deposition is in there, and the state, there was cross-examination.
Where is it written that a judge in one of these sentencing proceedings is required to credit hearsay?
It's the rule.
No.
Hearsay is admissible.
It's admissible.
Yes.
But that doesn't mean it has to be credited. You would have, the judge would look at that in the whole context to determine whether he would credit it.
The judge.
Have we ever said that a judge must credit hearsay as opposed to admit it?
I'm not sure what you mean by credit.
Accept it as truthful on its face.
No, the judge doesn't have to accept any witness's testimony as truthful, but what the judge has to do is has to consider it. He has to, in his order, determine whether it's mitigating in nature. He has to determine whether it's proved by the greater weight of the evidence and what weight to assign it. In this case, the trial judge did none of that. The trial judge basically treated it as if it was inadmissible. And of course it was admissible. The trial judge didn't say, I watched this video and I think this mother is lying through her teeth. I watched the teachers and, I think they're making it all up. The judge could do that, just the way the judge could with any witness. The judge didn't do that in this case. And I would
go back to the issue of the video and the significance of, we all seem to agree that the defendant began to leave, and then he's alerted to something. I'm still not sure that there was a clear response as to, there was no evidence, admissible evidence, as to what he thought the victim was doing but he thought it was a threat to him. Would that be fair to say? In other words, he
The defendant did
because he
not
hadn't
testify.
gone up to the front door to know it was locked until, as Justice Kennedy pointed out, until after he did the shooting.
The defendant did not testify. That would be the only way we would have direct
So all
evidence.
we know on this record is that he was planning to leave, having gotten his, having robbed the victim, having robbed the store, and then he sees the victim do something that causes him to either, we don't know, whatever it is, to go back and then either shoot his way in or to try to get back in there? Is that what we're assuming, that he was trying to get back in there to push the button?
What other explanation is there? And we also know he'd worked at convenience stores.
We know that because of admissible evidence?
Yes.
But I don't really know if in the
Several
robbery gone bad,
convenience
what does
stores.
it matter? And maybe this is where I'm trying to get. It's, I guess, if he went and he was just trying to get in to get the victim to push the button to let him out, that's
to do it
is even
himself.
better. But if he was getting back in there and he panicked, but he killed the victim, and is that still a question of whether this is a proportionate sentence or not?
Yes, I think it still fits squarely within these other cases. Like I said, the cab driver who got shot in the head, the fast food worker, there was a witness who was sitting outside in her car. She saw the defendant go in. She looked down at her sandwich, and the shot was fired, and that victim was shot in the head. We've got Terry, who shot a female at a gas station. We're not really sure exactly how that happened. Scott shot the laundromat customer in the face. Johnson took the victim, I guess this was a robbery, or he thought he cheated him out of some money, took the victim in the house at gunpoint, shot him a number of times, and then dragged him out to the porch where he's lying on the porch floor and shot him again in the face. Williams, he shot the victim 8 times, including in the back while the victim was face down. 3 more cases: Carruthers, Lloyd, and Rimbert.
Right,
So
but each
yes,
of those, we'd have to look back at what the mitigation was.
that's
to-
correct, and I can tell you what the mitigation was. In Terry, the trial court found no mitigation. He had offered that he'd lived on his own, he'd been unemployed for a long time, and he played video games at the mall, and he loved his girlfriend. Scott, religious faith, loves family and friends, and they love him. Absent father, good son. Overheard domestic abuse as a child, stopped a man from stealing at a grocery store. Johnson had 2 prior violent felonies. He'd shot 2 people before he shot this man numerous times. He had quote-unquote troubled childhood. We don't know what that means. He'd been employed. He was respectful to his parents. The trial court gave a lot of weight to the fact that he'd earned his GED and that he'd participated in high school athletics. Williams, GED, found religion in jail, capacity for hard work. Thompson, good provider and parent, no violent propensities before the killing, honorable discharge from Navy, raised in church, artistic skills. Sinclair, the trial judge didn't find this, but this court noted that there was evidence of low intelligence and emotional disturbance. He also was raised without a father figure. And I would assert that the mitigation in this case is equal to, or in some cases greater than the mitigation in all of these cases. If the court has no further questions, I'll save what I've got left for rebuttal. Thank you.
If it please the court, Steve White, Assistant Attorney General, representing the appellee. Some disagreements on the facts. Number one is, as the trial court found, there was no evidence that the defendant knew or thought that the glass was bulletproof. I mean, the proof is actually in terms of what he actually did. And let's back this up a little bit in terms of the video. The trial court found that this was not a panic reaction. That is, the shooting was not a panic reaction.
Now, when we look at the trial court's findings, this is on personality.
Yes, ma'am.
We've got the aggravators aren't changing. We've got the video. Now, I understand we give deference to findings, but when we're looking at proportionality, we've got the 4 cameras, we've got the video. Do you agree that in this situation, as to whether this was a robbery with the intent when he went in to kill, or a robbery where something occurred after he went in that then caused this, called a panic reaction, that to kill? Do you agree that he was leaving, he had robbed this victim who had been compliant, left the area, and then in reaction to what he saw, the pushing of a button, that he then came back?
We don't know what he saw. In fact, if you correlate the 2 cameras, Your Honor, cameras 2 and 3, getting to Justice Kennedy's point, whatever he saw, we don't know what he saw. The button's down here.
Okay, I guess what I'm asking is,
had
he completed the robbery when he left the area?
Yes, ma'am.
Okay.
The robbery was completed, and I cannot point to any evidence that shows that he intended to kill the victim. Otherwise, he would have shot him in the cashier's room before he left the cashier room.
And the defendant, was not only armed, but he was heavily sealed himself.
Yes,
So
ma'am. He had a glove on the left hand. The right hand, the trigger hand, was free. That is, was ungloved. A mask, the camouflage, a jacket.
So I guess in terms of knowing whether he knew it was bulletproof, whether he knew he locked the door, whether something happened that the victim did that alerted this guy that he needed to try to get back in.
The victim was standing up from all he could see. In fact, as a further point in terms of not being able to see the victim push the button, the defendant, he's kind of short, he's 5'4", and he immediately pulls out his gun as he's leaving on the exterior of the cashier room and has to angle the gun up like this to point it at the victim, and he tracks the victim as the victim is going towards the door to lock the cashier door to keep the defendant.
I understand all that happened after, but I guess what is it? Let me maybe understand it this way. In terms of whether this is a death case.
Yes, ma'am.
With Scott and the whole litany that has been recited, what does it matter? I mean, it is within seconds after this happens. It's terrible, to watch it is heart-wrenching. The panic or something sets in, and either he just accidentally or intentionally shoots the victim. Nothing part of his original plan. How does that matter in terms of proportionality and the cases where we've reduced the defendant's sentence to life?
2 points on that, and this goes to what the trial court found. The shooting was not panicked. The shooting was intentional. The defendant went back to the door. You can see it in the video. He's bending over to lay the bag down. He just doesn't drop it. This is after he fires once and fires again.
But where have we said in any of those robbery cases that a panicked, they're all the single aggravator? Again, the cab driver with the 2 shots, Scott with the shot into the face. It's still, the idea is that the original intent was robbery and there's no other aggravators. That's what I'm trying to find out.
A key feature of many of those cases, such as Scott, is the victim bucked the jack. Here, the robbery was totally complete, and the defendant decided to execute the victim. The defendant decided to go back to the cashier door and shoot the victim.
Well, but in fairness now, he was reacting, and I'm not by any means justifying anything that the defendant did here, but the reality is that he was reacting to what he saw or some perception that he had about what the victim was doing. Isn't that true? Isn't that an inescapable inference?
I cannot dispute that. That's correct, Your Honor.
Now, so why wouldn't we say at this point that this robbery has gone bad.
Well, the robbery was over, though, Your Honor.
Well,
The robbery was complete.
I don't think, for some purposes, this robbery is a crime in progress, okay? He's got the money. I think he dropped it, but this crime is still going on. He has not made good his escape, and it seems that you could infer that he felt some threat from what was going on inside the cage. Again, I would not justify anything the defendant does here.
Yes.
But why isn't this a robbery gone bad?
Well,
and do we have any case, a single aggravator case, robbery gone bad, where we have said that that's nonetheless proportionate?
Well, again, I respectfully disagree.
I understand, but
in terms of the robbery gone bad.
Okay, well, tell me why it's not a robbery gone bad.
The robbery was complete when he was fleeing. He decided to kill the victim.
Did he just say, "Well, I'm going to do it. Now I'm going to kill him before I go"?
He didn't go
that
back.
didn't happen.
He didn't go back to the cashier door and say, "Open the door." Then he said that later. He didn't threaten the victim. He just shot him.
Wasn't because of the movement. You just admitted because of the movement of the victim. Not justifying it, but that's what happened.
As Justice Kennedy pointed out, there's something about what the victim standing up that the defendant didn't like, and he decided
wasn't
to
just
kill the victim.
standing. He moved. I watched the video.
Well, I mean, he went like this, but there's stuff in the way here.
Okay. But, all right. I understand.
You know what? I just realized what you said, and I hadn't thought about this before. You said he came back and he was intending to execute this victim, but as he left, he couldn't have thought he executed the victim, because as he's trying to get out, he's saying, "Open the door, open the door."
Right.
He's saying it to the victim.
He's yelling it out. I mean, he does go back to the cashier room and looks in, and he apparently sees the victim disabled on the floor, dead or dying at that time. I mean, he is panicked. The judge found he did panic after he discovered he couldn't get out. That's when he panicked. And he's frantically trying to get out.
I just want to make sure your inference is you're almost again, and I think you said this is almost CCP, right? You said it's almost CCP and it's almost avoid arrest.
Premeditation plus, yeah.
I think that anyone watching the video can't see this as an execution. We were just in the case before,
right.
Anything approaching an execution style murder. It's first a panicked shot, and then maybe an intentional shot, maybe to kill him, maybe to disable him so he'd open the door for him.
Again, I just respectfully disagree. You're on putting the bag down, assuming the shooter stance, and firing the second shot. That, to me, and while the victim is trying to keep the door closed and lock it, the victim's not trying to get out. The victim's trying to keep the door closed and lock it. The door pushes outward, and the victim's pulling it towards him and locking it.
But again, whatever he's trying to do, whether he's trying to kill, maim, or accidentally, he's doing it because he's trying to get out of this place, the defendant, with his goods. And I guess so that goes back to the question about that the robbery of the victim is complete, but the robbery of the store getting out is not complete.
Well, the trial court expressly found that the evidence did not support the inference that the defendant knew at the time that he shot the victim that he was locked in. And in fact, if you look at the video, there's stuff in the way. The defendant can't see what the victim's doing. But as Justice Kennedy pointed out, he didn't like whatever he saw. But there's no evidence to prove.
And it's kind of contrary to any inference that he knew that the door was being locked, that when he gets to the door, he seems to be surprised. I mean, he's going,
right.
After he does the shooting, he goes to the door to go out.
He pulls on it first.
Right.
Yeah.
But I mean, he's shaking it. I mean, he can't get out. And then
right.
he cries out for it to be open. So it just seems like this is not a person who's expecting the door to be locked.
As the trial court in fact found, when he goes back to the cashier door and shoots at the victim twice, he doesn't demand open the door, open this door, open that door, or anything.
But putting all that aside, say we disagree with you about this being a robbery gone bad, and if we concluded that it's a robbery gone bad, do we have any single aggravator case of a robbery gone bad that where we've said there's a robbery gone bad, or there's circumstances that amount to that, where we have upheld the death sentence as proportionate?
I could not find one, Your Honor, but
I'm sure you looked.
I did look, and I did inquire of colleagues. But I also have not found any case where it's like this one, where you actually see with clarity the facts of, beg to differ, the execution-style murder of the victim. That's all he went back to that door to do, where it was not, unlike a lot of the cases that my opponent cites, where it was not the victim bucking the jack, standing up in the laundry saying, "You ain't taking my money." Here the victim is totally submissive.
In a way, it is analogous because the victim did something that this defendant in his, I mean, he's not exactly walks in calmly. He's, you know, he's very much like he sort of knows what's going on.
He's very methodical.
He said, well, I wouldn't exactly call it methodical. Very, very much what he knows. He wants he says, give me the video or the DVD. So again, even though we don't know a lot about what he knows, he thinks there might be security and he's wanting security.
He is very preoccupied with the video, yes, ma'am.
Right. And so we don't know why he's turned back to either shoot or get his way in there, but it is in reaction to something the victim did that he perceives as a threat to him being able to successfully complete the robbery and get out of there. I mean, I think that's the most logical inference. Now, you know, again, I guess we're going to beg to differ, but
yes, ma'am.
It doesn't, the idea that you're calling this an execution-style murder is as if it's something close to CCP is concerning me.
Well, I think a way to harmonize the state's view with Your Honor's view is that he decided to execute the victim after he went in the store and saw the victim standing at the counter. That's when he went back to the cashier door with a singular purpose, to shoot the victim. That's what the video shows. And so the issue of when he gets to the front door and he says, open the door. That's when he panics. I mean, he's yelling out, and he knew that there was somebody else around somewhere, although he didn't see him at the time. Mr. Hardy, who was the customer who came in, was hiding at the time. But the defendant did hear somebody come in the door. He glanced up and then went about his business of continuing the robbery. Unlike a lot of the cases.
Now, that would be a different case, right? If he then sought out this other
and the trial court found that as mitigation, that he did not seek out the customer who there was evidence that he knew somebody else at one time went in the store. The trial court
heard the ding when the door opened. Is that it?
Yes, sir. Yes, Your Honor. The chiming. Right. I don't know whether bird sounding or whatever. But I would again respectfully disagree with Your Honor, Justice Parrington, in terms of the mitigation, both this merging into segueing into issue one, being compelling with or without the video. And of course, as the state argued at length in its brief, the defendant created this situation. He insisted time after time after time, and the trial judge conducted one colloquy after another.
No, I didn't say, I said it was unfortunate that the defendant, I agree the defendant thwarted the presentation of mitigation. But yes. I clarify, I was saying it's unfortunate because I think they could have presented a very compelling case of mitigation. I agree that the defendant, as unfortunately happens not a lot, but more than we'd like, doesn't see that the key to whether he gets the death penalty or not might be in his own hands as far as what happened in his life up till the age of 22.
I would urge Your Honor to compare the video, which, I mean, assuming the whole package, let's just assume for the sake of argument the video had gone in.
Now we're talking about the video
of the family and the three teachers, the mother, the grandmother, and the three teachers. I would suggest to Your Honor that you look at the cross-examination the prosecutor could have done with those victims and ask, well, would this mitigation have still been compelling? And I summarize those on pages 56 to 58 of the state's answer brief in terms of all of the negative baggage that video would have come with in terms of the specific cross-examination questions that the prosecutor
I appreciate that. And I think the jury or someone knew that it was aggravated assault when he was in high school and that he had used, it was a metal bar.
Yes,
okay,
ma'am.
so that's there.
50 suspensions for disruption. He said minor disruption. I mean,
You know,
and
having,
the PSI.
unfortunately, we see too often kids that end up in this, but he ended up graduating high school. I guess what I thought was compelling, just so
Yes, ma'am.
appreciated, is that this is, again, a young man that is, again, the product of an arranged marriage, 13-year-old mother in a war-torn African country, immigrates to this country. In the end, he graduates high school. We don't really know enough about what happened between the time he graduated and he goes, and either way,
know he
he's
wants to
either
live with the
in
father.
prison, either he's on death row till he is executed, or he's in prison for the rest of his life. So we have this double tragedy. We're just trying to make a decision here whether he is going to go on the list of 400-plus defendants that will be maybe at some point executed,
Yes,
or
ma'am.
spend the rest of his life in prison.
Yes,
That's the
ma'am.
only choice that is there.
And in terms of the mitigation, I think it's also noteworthy, there's no statutory mitigation, none. There's
Let
no,
me ask you about the mitigation.
there's no mental mitigation.
The defendant argues that the trial judge erred. Did the state allow this DVD in without objection? And if that's the case, should the trial judge have considered it?
Well, in terms of the exact quote from the prosecutor, he said, this was early on in the Spencer hearing, he said, I don't have any objections because pretty much everything comes in for the Spencer hearing, pretty much to that, words to that effect. But then he says, I want to go over or review that with Your Honor later in the hearing. And he spends, it must be 10 pages going through all the reasons why the trial court should not accredit, should not consider as probative the things on the DVD. And the statute says probative evidence, 921141, and a fair opportunity to rebut. And here, this evidence, because, I mean, these two go hand in hand, the prosecutor had no opportunity to cross-examine. It's totally ex parte. 6 months earlier, 8 months earlier, they did this DVD and didn't even give it to the prosecutor until the day before the Spencer hearing. The defendant didn't even make up his mind that he wanted only the investigator to testify and not to use the family. I think that was October 13th.
How does it work with Mohammed? And this was a partial Mohammed case. It was a PSI. The PSI I have not looked at, but has, I mean, the state's not contesting that the other parts about the age of his mother, the fact of when he came to this country, the fact that he graduated high school.
The investigator testified to those
So
facts,
those
Your Honor.
are, so
Yes.
really,
Yes, ma'am.
I'm not sure in terms of what, it's not like, again, there is, what is it we're actually arguing about? What that should have been considered that wasn't, that might have changed something? Since the judge did consider some of this evidence, what is it that the state felt shouldn't come in that the judge then ended up not considering? What are we talking about?
In terms of going down the mitigation that the trial court rejected because it was hearsay without the right of confrontation, this cross-examination. If we go down the list of mental mitigation, age, the trial court rejected because of the methodical way that the crime was committed.
Well, the age is 22. That's not going to be met
Right.
in
He's
any
almost
event.
23, actually, at the time
Right,
of
so
the
that's
crime.
not, that really didn't have to do with him presenting
The
mitigation.
defendant panicked. The trial court rejected and said, no, he panicked after the shooting and not before. Defendant believed the glass is bulletproof. The trial court said that's...
No, I'm talking about stuff that would have to do with the video, the video evidence of those three witnesses.
The defendant immigrated, which was both testified to by the investigator as well as on the DVD. The trial court found and gave slight weight. He said, well, a lot of people immigrate and they do just fine. That's not, I don't consider that a weighty mitigator. That he was a diligent student, the trial court rejected because it was based on the non-confronted hearsay in the DVD.
Well, was there, as far as him being I mean, I don't know what that means. I mean, a diligent student. We know that he got in a lot of trouble in high school.
50 suspensions for disruption. That's kind of negates that
Now,
diligence.
how do we know about his high school record? Were the records put into evidence?
His high school diploma was put into evidence, Your Honor.
So we know
but
he graduated high
we
school
know he
despite
graduated,
everything. He
and
got
the trial court found that. But in terms of how he behaved in school, that was non-confronted, non-cross-examined.
So what you would say, I mean, the way we look at this is that he had a very rocky high school career, but he managed to graduate.
He's the one who told the PSI writer that he had 50 suspensions, and he tried to minimize it. 50 suspensions for disruption, I would not characterize that as minimal. That was
And
certainly...
some of this information was in the PSI also about...
Some of it was,
yeah.
yes, Your Honor. The suspensions were in the PSI, which the defendant told the PSI writer.
And some of that background information also in the PSI.
And then the trial court thoroughly considered the PSI. It was the stuff, I mean, getting down back to the list of mitigation that the trial court rejected, it were the things that were not in the PSI that the family testified about, that the trial court rejected because of no opportunity to cross-examine. And this gets to the heart of the reliability of the evidence. I can't emphasize that enough, and that's what the trial court was troubled about.
But it sounds like this trial court, no matter what, was like he was saying, well, he did this, but I don't really find that mitigating. I mean, the idea being that once a trial court gets in his or her mind that it still doesn't mitigate that he committed this crime, you sort of have that's why we look at proportionality a little bit differently. So
yes, ma'am.
we still take this defendant with all this isn't a 50-year-old that had a life of crime. This is somebody that something went really wrong in his life and ended up in this tragedy, but there's nothing to show that he had a mental health issue, that he had low IQ or anything
no,
like
ma'am.
that.
In fact, he was intelligent. That was proposed as a mitigator. And
It's always right? It's either low or high.
He had a loving family. That cuts both ways, too. He had every opportunity once he came here because they proposed that he had a loving family.
Do we really know?
And the trial court found that.
What do we know about this defendant either way from the time he came to Florida? Employed, do we know anything about that until the time?
We know from the PSI he job hopped a lot. There were a whole bunch of jobs that he had. We know that he has quite a few arrests, including resisting a police officer without violence. I think there was a withhold on that.
The PSI shows he was working in other convenience stores.
Yes, ma'am. I think several of them. I don't remember the exact number, but there's several that were indicated in the PSI. And it's interesting that the PSI continually refers to the father confirming those facts. The father's not on the video, but apparently the father was the one who confirmed a lot of the facts in the PSI, and the father is the one the defendant wanted to go live with. He wanted to leave the mother and go live with the father in Jacksonville. Supposedly there's some indication somewhere that the father may have abused him at one point. Well, the defendant wanted to live with the father, and the defendant said that was a cultural misunderstanding. So there's no evidence, credible evidence of any abuse whatsoever. There's no evidence whatsoever of any mental health illness. There's no statutory mitigator, period.
Not yet.
And in fact, if you...
I mean, unfortunately, what we see is sometimes we don't see it here, we see it in post-conviction. That's what
I have no doubt that defense counsel will be hindsighted in post-conviction. But in terms of the other mitigation, I mean, just going down the list, if Your Honor wanted me to continue with that. The fact he was a hard worker, the trial court said no, that's based on the non-confronted hearsay, that non-cross-examined it, but it's also in the PSI that he job hopped a lot. So, I mean, that cut both ways. Defendant loves his family and his family loves him. The trial court found that based on the investigator's testimony and gave it slight weight. Religious home, the trial court rejected, but again, this cuts both ways like having a loving family. You know, you're being taught these values and yet you disregard them and engage in these 50 suspension actions in school, and you resist a police officer and you run from the police.
But your argument about mitigation, though, it is always ironic that all mitigation can run both ways. cases where they introduce their other siblings, and the siblings avoid a life of crime, and they didn't. So you get to a point where, other than some serious mental illness at the time of the crime or being 17 or 18, almost any mitigation, say,
To
well,
some degree, yes, ma'am.
can cut both ways. So I don't think it's unique to this case, is what I'm saying.
Defendant abandoned by father, the trial court rejected because no cross-examination in the video, but also the mother testified, or excuse me, didn't testify. She was not under oath in the video. My mistake on that, which is another problem with the video. But the mother actually indicated in the video that the defendant chose to live with the father. I mean, you know, and the father was repeatedly consulted on the PSI.
So maybe it would have been better if the judge just said, well, I'm finding this, but it's giving it little weight because he went back to
No matter
live
how
with
you
him.
look at it, they did
I think
not
that's
prove.
that is what Ms. Carey's saying. It's sort of like he would have been better off if he had just taken it and then said, but this is all the contrary evidence, so I'm giving it no weight or little weight, as opposed to just saying, I'm not considering it.
Of course, the optimal situation is if these witnesses have been called and the prosecutor had an opportunity to cross-examine
What is
them.
it that where the defense lawyer said he didn't want to spend the money to go
That's
out
at
to
one point,
Seattle?
yes, sir. In fact, at one point, I think it was during the guilt phase of the trial, the trial judge wanted to move the penalty phase closer to the trial. I think it was scheduled for October the 18th, and the trial started on October the 4th and went to the 6th. And during the trial, the judge says to counsel, let's move the penalty phase closer. And defense counsel says, no, Your Honor, we have a lot more. We can't get together the penalty phase and evidence in time for that. Well, what did they end up doing? They just ended up trying to use the video and calling the investigator.
No, I thought there was something where he said, I didn't want to invest the money to go out to Seattle.
I think that was a little earlier when he mentioned that they were considering, that may have been before October 4th, I believe, or before the 6th anyway. But yes, Your Honor, the defense counsel did mention that he didn't want to spend the money to fly there. They were considering not flying people in from Seattle or
But
wherever.
didn't the judge also would have given them permission to do it telephonically?
Absolutely,
This
Your
is the
Honor.
case, okay.
The judge bent over backwards.
The judge bent over back, absolutely.
Yeah, absolutely. These witnesses can appear for the...
Plus, weren't they in fact they were present at court during the hearing?
We know some family was there, Your Honor, but we don't know exactly who. The family's mentioned a couple of times, but we don't know exactly who they are. One time, defense counsel says that one of them was Miss Baena, but then he characterizes her as not speaking English. Well, she speaks English because she was the translator in the video. By the way, she was the translator in the video for the grandmother, and the translator, the mother, you can hear her voice crackling. She's crying as the translator. You're supposed to have an objective, neutral translator in terms of when you have somebody who doesn't speak English. And certainly the mother was not that. I mean, in terms of the camera honing in on the mother's face, oh yes, well, witnesses, a family can cry on the witness stand in terms of showing compassion and so on, but the camera zooms in on the mother as she's crying. And the mother again cries when she's translating for the grandmother. But in terms of the ex parte nature, one-sided nature, non-cross-examined nature of that video. In terms of had no friends, reject, I think the mother just barely mentions that. Again, I would submit that that's totally inconsequential. Defendant came to the defense of somebody who was bullied. It's interesting on that one, the prosecutor, after the prosecutor says no objection to the video and then goes on for pages and pages about the cross-examination he was deprived of, also wants to tender the facts of that prior incident with the metal bar, and the defense objects on the ground of hearsay, and the judge sustains the objection as to that particular mitigator. In terms of the next one, respectful and obedient, well, we've got an aggravated of fleeing and attempting to elude. The prosecutor could have cross-examined witnesses on. We've got 50 suspensions for disruption in school. In terms of that particular proposed mitigator that the trial court rejected. And I believe that's the last one in terms of the ones that the trial court refused to consider and said that it was based on the uncross-examined, untested, unreliable video of the family, unsworn video of the family. In terms of all the defense, all the other side's cases, you don't have any case where you see with absolute clarity what happened. You don't have any cases where the robbery was over. That is, all these cases, either there was some ambiguity as to what happened, the victim bucked the jack during the robbery, not after the robbery was over. And in a lot of those, you have statutory mitigation. You have no statutory mitigation, or you had some sort of mental mitigation, none here. Thank you, Your Honor, and the state would ask you to affirm.
Thank you. Rebuttal?
Yes, Your Honor. I know I said this in my initial argument, but based on the state's argument, I'd like to just say once again, at the trial, the prosecutor objected to this videotape testimony and the deposition of the mitigation specialist coming in at the penalty phase before the jury. At the Spencer hearing, the prosecutor did not object. He said, "We have no objection." And then he said he had watched the video and he wanted to make arguments, quote unquote, just for the record, to support his objection to admitting the videotape before the jury. That's in the record, volume 15 at 1399. So the state did not object to this testimony. The state submitted one piece of evidence to rebut some of the testimony, and that piece of evidence was the conviction, the judgment and conviction for the third-degree assault for the schoolyard fight that the defendant got into when he was 16 years old.
But here's the issue. The judges, in terms of proportionality,
Yes.
how much the judge looked at the mitigation or not, in terms of what this video, which I haven't seen, would show, it's in evidence. If somehow that was what was going to be a matter of life or death, isn't Mr. White correct that we do have to consider the 50 suspensions, these other these other things that are in the PSI? We can't just take the good part and then forget about the other parts of it. So as we're looking at it, we got to see the whole package, which is this is not it doesn't change that he immigrated from this country, but that he certainly, or that he graduated, but it wasn't like he just went through school without problems. So I don't see how we escape, if we look at the whole picture, also looking at those parts. So I don't know that it gets any differently.
Well, I think the court has to look at the whole picture of mitigation. Okay?
But you can't have a mitigation case where the defendant doesn't want to put on the mitigation, throw in a videotape, and say the judge should have considered that. I just have a problem with some basic rules of examination, cross-examination. Otherwise, we'd be encouraging defendants to say, we're just going to put in these videotapes.
But, Your Honor, I'm not asking the court to only consider what we consider mitigation. I'm asking the court to consider everything in the record. That's what the law says. The trial judge has to consider all possible mitigation in the record and evaluate it.
I think it's just, maybe it's that I think that with him preventing the defense lawyer from really putting on a case of mitigation, even if the judge if this wasn't a single aggravator case, to me, the mitigation doesn't go from being sort of minor mitigation to great mitigation. And unless you can show me something that would just change that picture, I think we're still dealing with the one part of the equation, which is it's a single aggravator case. And I'm not sure the mitigation picture is going to change that one way or another. That's both good or bad from your point of view.
I'm not sure what the question is.
Well, the question is what is there in this videotape that would change the nature of this mitigation, with the fact that he also was 50 suspensions and aggravated assault and all the other things that happened when he got to Jacksonville?
Your Honor, this mitigation is comparable to the mitigation in all the other cases. This was He hit a kid during a fight between two groups of people in the schoolyard at age 16. That doesn't erase that he was born and raised in a third world country. The judge didn't even consider that he was born and raised in Eritrea, Africa. The judge didn't even believe that was true. The judge didn't consider that his father left before he was born, so he had no father figure until he moved to the U.S. The judge didn't consider that. The judge didn't consider that despite the fact that he did get in this fight, he came to the alternative school. He worked very hard. He did everything he had to do to complete his work, even though he wasn't necessarily very good at the work. He was a diligent student. He was employed. He was a respectful, obedient child. That does not negate the fact that he also got in this fight. As far as the 50 suspensions, the only evidence we have of that is that he told somebody about that. We have no idea if that's true or what they were for. That may not be mitigation, but it doesn't rebut or refute all this other mitigation, which I submit is comparable or greater than the mitigation in these other cases. The other thing I'd like to point out is, no one's mentioned this before, you watch the videotape, he's not very handy with this gun. When he runs back, he forgets that he's dropped the money on the floor. He runs back, and as he's bending over to grab the money, another shot's fired. Who knows where, but that appears to be some accidental shot fired at that time. There's a third shot there. And then just one more thing I'd like to respond to Justice Kennedy's statement, which I understand. After he has fired the shots and he runs back to the door, the first thing he does is pull on the door. And I think, Justice Kennedy, you say, well, doesn't that mean he didn't know the door was locked? Well, I would submit that if he thought the door was being locked, and he would still pull on the door when he went to the door. Maybe he hoped it wasn't locked, but clearly he thought...
Anybody going out a door is going to pull on the door.
They're going to pull on the door. So I don't think that means that he didn't know the door was locked, or that it's not reasonable to infer that he saw him hitting the lock switch, and because of his previous employment in the identical store, he knew what was going on. I think that's all, Your Honor. Thank you very much.
Thank you for your arguments. Court is adjourned.